So good afternoon. My name is Tom Hughes. I'm a Senior Market Services Executive at the IUA, and I'll be chairing the session this afternoon. So thank you very much for joining the first in a series of 4 aviation wordings masterclasses that we are hosting with our IUA Junior Aviation Practitioners Working Group. So before we do get started, I have a couple of very quick pieces of housekeeping to draw your attention to. The first is that we are recording this session and we'll be circulating a link to the recording along with the presentation slides after the session. You may already have spotted that there's a Q&A facility within this webinar platform. Please do make full use of that and pose some interesting questions to our speakers. And then we will be using, alongside the Q&A, a poll facility. So you might see some questions pop up at various points during the session to make sure that everyone is alert. And please do respond when you get that request, and then we'll take a look at the anonymized and collated answers. The very last piece is just to say that I sent, prior to this session, a collated clause reference pack for you to take a look at during the session and perhaps after the session as well. So hopefully you receive that directly via email. If not, I'll be putting a link in the chat in a couple of minutes' time so you can access via that link. So just looking at the Q&A, I would stress that we are, of course, all here to learn today, and there really are no incorrect questions. However, our speakers are here to provide their own individual views on the rationale behind model aviation clauses and, of course, their theoretical operation only. So the sum total of that is that we will not be answering any questions related to ongoing coverage matters in the market. So please can I ask that you refrain from asking those questions. So Tony, if you could just move to the next slide, that would be great. And we'll have a very quick look at the format for this masterclass series. So we have four virtual wordings masterclasses. Of course, this is session 1 today. And the idea here is that we will look at commonly used aviation wordings and clauses that you may come across in your day-to-day roles. And the sum total of those wordings masterclasses should give you a very good overview of those key wordings that are in use in the market. Then following the 4 wording sessions, we have 2 in-person claims masterclasses, and they're not just for claims practitioners. We'll be very pleased to welcome along underwriting and broking representatives too, who I'm sure will find some benefit from the sessions. During those sessions, we'll be working through an aviation large loss scenario in order to establish the types of key considerations that aviation practitioners should be looking at when dealing with a large loss. So if we can just go to the next slide. So, of course, I mentioned that these sessions have been organised by the IUA's Junior Aviation Practitioners Working Group. And you may be wondering what on earth the IUA Junior Aviation Practitioners Working Group is, but the clue is very much in the name. So we convened a group a few months ago now, just at the start of this year, with practitioners from across the aviation broking, underwriting and claims communities. You can see on screen an overview of the key aims and objectives of that group. But broadly, we're looking at providing a forum for junior practitioners to share their experiences and views and, of course, learn from one another. We're focusing predominantly on providing education and training for junior practitioners in the market, promoting good practice, and, of course, considering and contributing to discussions on pertinent market developments. So if we just move to the next slide, it's now the time that I can introduce our 3 expert speakers. And having been fortunate enough to work with each of our speakers over the 7 years that I've been in the market, I can vouch for the fact that we are in very safe hands this afternoon. So first of all, we have Jette Varnels, Technical and Wordings Manager for Aerospace at AXA XL, Gareth Howe, who's the Underwriting Technical Director at Global Aerospace, and Sophie Moisan, Chief Legal, Claims Advisory and Institutional Officer at La Réunion Aérienne. So I'll ask a very quick question to each of our speakers. I'll start with Jette. So can you very briefly summarize in a couple of words why you have found yourself in a wordings focused role, and what do you enjoy most about that role?
That's a trick question because you didn't mention the second bit before. But welcome to everyone, and thank you for joining. Wordings are, of course, the backbone of the insurance contracts, but how I found myself in looking at wordings was more by accident, I would say. I started my working life as a as a trainee aviation technician in a broking firm. I found the work very interesting, and in order to understand what we do, it's important that you understand the wordings. So it was just really a natural progression. I then found that I enjoyed the technical work more than the sales work, and so I stayed within that part of the business, becoming quite sort of involved in dealing with clients and the brokers in discussing the wordings and the technical aspects of the construction of the policy and the coverage given to our clients. I moved to the underwriting side some years ago, and found that the work was similar, but obviously when you're on the underwriting side, then you've got to put your money where your mouth is, and we pay claims. So therefore you have to have a stronger understanding of what the wordings really intend. And you know, we can say most things, but we should try and be careful that we say what we mean, and that we, as insurers, provide the coverage that we intend to provide, that we've received a premium for, and that the client understands the coverage that they're purchasing. But I found the work very interesting, and hence I've stayed working with it. I enjoy working with clients and the risk managers. I don't enjoy the sales quite so much. That's it. Thank you.
Thank you very much, Yeda. Sophie, can I go across to you now?
Yeah, but I think Yeda said it all, so I don't have much to add, really. I had more or less maybe the same evolution as Yeda. I started maybe not the very first part of my career, because I was a lawyer and advocate, as we say here in France. So maybe that also helps getting some interest in the wordings. But I started working for a broker, and I have spent most of my time working for a broker before joining LRA as an underwriter. I think I don't feel myself as a specialist wording person. I have done many different jobs in my career in aviation insurance, and I think it's always an added value to have some experience in the claim side, in the underwriting side, or in the broking activity, and also in the wording. I think what makes a nice career is to have some experience in most of the activities you can have in aviation insurance. That's certainly what I've liked, and I think it's very useful when you are dealing with the wordings to have had some experience with the claims, and some experience also in negotiating with the clients and the brokers. Getting a kind of overall view of the situation. So that's it.
Thank you very much, Sophie. Which means we'll go last, of course, by no means least, to Gareth. Gareth is going to tell us why he loves wordings, I'm sure. Gareth.
Thanks, Tom. Oh, you made it hard for me now going last, haven't you? Yeah, I mean, for me, a bit like Sophie, I've had a number of roles within the industry, as in broking houses, as an underwriter, and as a head of wordings here at Global Aerospace. For me, it's a critical part of what we sell. This is what we're providing. It's the promise to pay, and understanding that contract is critical. Certainly, as I look back on my more junior career, I wish I'd had some sessions like these that would have given me a more in-depth knowledge of wordings at that stage in my career. So I think this is a valuable sessions that the IUA are hosting, and I hope everyone has value from these today.
Thank you very much, Gareth, and thanks to yourself, Yeda, and Sophie, for taking the time to join us and to provide your views. So I will hand back to you now, Gareth, and we'll move on to the next slide and ask that you prompt Tony when you want to move to the next slide, and we'll go from there. So thank you very much.
Thanks, Tom. And yeah, Tony, we can go to the first slide now. The focus for today is on the coverage that we provide to aircraft operators. Now, this could be a GA operator, it could be an airline, but we're just looking at aircraft operators today. I've put on the screen there a few of the different wordings that might be used to achieve providing coverage for an aircraft operator. hopefully most of you will have heard of AVM1C. It's a London market standard for providing cover for a general aviation operator, published back in 1998 and still heavily used today for GA risks. That form was updated and modernized in 2016 with the AVN1D form, although the take-up of that has been slow, I would say, and we still see a lot of risks that are placed on an AVM1C basis and then heavily amended, in part to bring them into line with what AVM1D provides and in part to provide extra modifications. Other options that are out there are a number of insurers have their own forms, be it a GA wording and airline wording. Similarly, many of the brokers have their own forms for providing this cover. And then at the other end of the spectrum, we've got manuscript wordings where you might have a completely bespoke policy for an airline that's unlike any other policy in the market. Tony, if we go to the next slide. Today, we're going to use AVN1C as the basis for the discussion. You've all received this in your packs. I'm not expecting everyone to have read it, nor even to have it open now. We'll put the content that you need on the screen. What I would say is that the core coverage, which is what we're talking about today, is going to be similar in whatever wording you're looking at, whether it's 1D, 1C, a broker wording, a manuscript wording. The core coverage is going to be very similar in that we're providing first-party coverage for the aircraft hulls, and we're providing third-party liability coverage for damage to property and bodily injury to third parties. What we've got on the screen here is the insuring agreement from the hull section of AVM1C, which is what we're going to look at first. I don't propose to read everything out on the screen because that gets a bit tedious, but I have highlighted some key provisions that I wanted to talk about. The first point to state there then is that this is an insurer's option as to how they resolve a claim under the hull section. So the insurer has the choice as to whether they're going to pay for a new aircraft, replace it, repair it, whatever is the most appropriate method that the insurer feels for resolving that claim. That theme runs throughout the whole of this section 1 of AVM1C. The insurer's consent is required for various things, or it's the insurer's option as to how to resolve various matters within the hull section. The second thing is that we're providing cover for accidental loss or damage to the aircraft. Now, one thing that you might want to look out for is that this accidental loss or damage is often amended to physical loss or damage. So you should check in the slip or the wording as to exactly the basis of the cover when you're adjusting a claim. The next point to talk about is that in AVM1C as standard, we're talking about scheduled aircraft. So there will be a schedule attached to the policy which states which aircraft by reg tail number are covered by the policy. Often then you'll find an additions and deletions clause, something like AVN 19A, which determines how aircraft can come on and come off the schedule. So it might be that they're automatically whatever the operator needs. It might be that insurer's consent is required to add and delete aircraft. So you need to look at that when you've got a loss as to whether the aircraft is actually covered by the policy. I just wanted to touch upon disappearance. So loss of the aircraft also includes if the aircraft has disappeared and can't be found. So in AVM1C as standard, we talk about an aircraft disappearing and being unreported for 60 days. That is nearly always amended to a lesser period. So it might be 30 days, 7 days, whatever the period is that's been agreed between the broker and the underwriter. So if you've got a disappearance case, you want to check what the provisions are there for when the policy will pay out for loss of the aircraft that's disappeared. Part B of the insuring agreement is something that's paid in addition, and we call it emergency expenses here. What we're really talking about is expenses for the immediate safety of the aircraft that are going to prevent further damage to the aircraft. So if you've got an aircraft that's perhaps sustained a hard landing, run off the side of the runway, there might be expenses that you want to incur to stop the aircraft being further damaged in the area where it's located. And as part of AVM1C, we would pay up to 10% of the amount insured for that aircraft for these emergency expenses in addition to the hull value. Next, we're going to go to one of our polls. So Tony, if you could put the first poll up, that would be great, please. So In the event of a total loss of an aircraft, what is an insured most likely to receive from the insurer? And we've got 4 options there: replacement with a similar condition used aircraft, replacement with a new aircraft, payment of the current market value of the aircraft, or payment of an agreed value of the aircraft. Which, if you could make a selection from those 4 choices, and then we'll take a look at the answers. I'll give you a few seconds to do that. I should stress that there is no right or wrong answer to this question. Okay, Tony, should we have a look at the results when they're in? So most people have gone with payment of an agreed value of the aircraft, which I would completely agree with. That is the most likely resolution to a total loss claim, is that a fixed agreed value would be paid out. Tony, if we go to the next slide now. Next, we're going to look at some exclusions, and these are exclusions that are specific only to the hull coverage. The first one is what we generally call our wear and tear and breakdown exclusion. So I've highlighted the perils there that are not covered by the hull section. So wear and tear, deterioration, breakdown, defect, or failure. And in AVM1C, we have this concept of a unit. So these are wear and tear caused in a unit of any aircraft, which are in the AVM1C wording defined as components together that have been assigned an overhaul life. So for example, an engine is a unit of the aircraft that has an overhaul life. And in that unit, we're not going to cover those perils. Now, why would we not want to provide cover for those things? Is that hull insurers generally want to protect themselves against things which are considered to be operational costs of operating the aircraft, or potentially issues that are a warranty claim that the operator should pick up with the manufacturer of those components. But these perils are not covered by the hull cover. The second part of this exclusion, part B, is what we call the ingestion exclusion. So we're not going to cover damage to a unit, so for example, damage to an engine, by anything which has a progressive or cumulative effect. However, single recorded incidents are covered. So if you have an identifiable recorded FOD incident, then that is going to be covered by this provision, but not something where the effect on the engine is progressive or cumulative and happens over time without any identifiable incident. The final paragraph of that exclusion is important as well. So loss or damage to the aircraft that is consequent upon A or B above is going to be covered. So if you have an engine that fails on takeoff, for example, we're not saying that that claim is not covered because the engine failed. We're saying that the damage to the aircraft that's consequent upon that failure is still covered by the policy. Tony, if we go to the next slide. Next, we're going to have a look at some of the conditions that apply only to the hull section again. So the first one there, we talked about it briefly before. The insurer's consent is required before dismantling or repairs take place to the aircraft. So the insured shouldn't go ahead and repair the aircraft by whatever means they deem appropriate without the insurers being informed and the insurers agreeing to the repair methods. The only caveat to that is if there's something that's required in the interest of safety or to prevent further damage, which would obviously reduce the loss to insurers, then that can take place. But in all of the cases, insurers' consent is required. The next part is to say that insurers pay for repairs and transport of labour and materials that are required by the most economical method. So that means that if spare parts are required, the insurer may choose to use the most economical method to get those spares to the location where they're required. So that could be by ship, could be by road, could be by whatever means necessary. If you're adjusting a claim, you want to look out for whether this clause has been amended, because it may be by the most practical method, by the fastest method, as agreed between insurers and the insured. You want to check what that is, because sometimes parts may be moved by air freight because it's quick and the insured wants the aircraft back in service as fast as possible. So you need to check whether that's provided for by the policy. The next part is that I've highlighted the word replace there. So if the insurers are going to replace the aircraft, under AVM1C, that's on a insured value basis. The majority of risks, as most people are aware, judging by the poll, are written on an agreed value basis. And if you're looking at an AVM1C slip, you're going to see an AVN61 provision in the conditions, which gives insurers the option to replace the aircraft in the event of a total loss with payment of an agreed value. So that's fixed at inception of the contract. So the insured value, agreed value of the aircraft is X million pounds. And in the event of the total loss, that amount is paid out. If we then look at the provisions just below that, so I just wanted to touch on II. So once insurers have paid out for replacement of the aircraft, coverage for that aircraft is terminated, even if the aircraft is kept by the insured. So you might have something that's paid out as a total loss, but there is still some intrinsic value in the aircraft and it's left with the insured. But at that point, it's deleted from the whole section, so the coverage doesn't automatically continue. And then the third part to that clause is that replacement aircraft. So if an aircraft is being replaced, then it will be in reasonably like condition. This is a like-for-like replacement. It's not as new. And this is the concept of betterment. So we're not going to provide for an aircraft that puts the insured in a better position than they were prior to the loss. It would be a like-for-like replacement. Tony, if we go to the next slide now, please. So now we're going to talk about what might be deducted from the claim. So the first one, amount specified in Part 6B of the schedule, that's the deductible for the aircraft. So every aircraft's going to have some kind of hull deductible that would be deducted from the amount of the claim, typically only in the event of a partial loss. So if it's a total loss of the aircraft, generally deductibles don't apply and the amount is paid in full. The second part of that is a slightly wordy way of saying betterment in any unit. So overhaul costs. So if you've got a unit of the aircraft, say it's got an overhaul life of 1,000 hours, at the time of the loss, it's already racked up 500 hours, then insurers are not going to pay for a brand new unit. They're going to pay 50% of the cost of a brand new unit to reflect the usage that had occurred in the unit prior to the loss. And then part D, in the event of a claim, there can be no abandonment of a damaged aircraft to insurers. So whilst insurers have the option to take salvage on an aircraft, there is no obligation for them to do that. And the insured is responsible for the damaged aircraft, even if it's been paid out by insurers as a loss. Tony, if we go to the next slide, I think that's the end of the hull section.
It certainly is, Gareth, and we have actually got one question. So I think, given that we've probably got a couple of minutes left on this section, I thought perhaps I would put it to you now before we do move on. So the question is, why is accidental loss commonly amended to physical loss? And that is within paragraph 1.
Yeah, where we talk about intentional acts and loss or damage to aircraft, we talk about accidental that can't include an intentional act. Physical loss or damage is a wider interpretation of loss or damage. So it wouldn't necessarily have to be accidental loss or damage to the aircraft. Generally, it's seen as the preferred method for deciding what loss or damage is, or rather explaining loss or damage.
That's really useful. Thank you, Gareth. Sophie or Yeda, would you like to
Could I
add
add just a little bit to that?
Please do. Yeda, go ahead.
Hello?
Yeah, we've got
Can
you.
you hear me?
Indeed.
Right. Yeah. Right. Because could I just add one little bit to the bit that Gareth said? Because I'm up next, aren't I, with the AV458B exclusion.
Absolutely. Please do.
Right. The first bit, in addition to what to what Gareth was saying about the physical, was to deal with the situation where an insured makes his own repairs, and that repair causes a failure. That could be argued that that's not accidental, but at the same time, of course, it is, and it's to avoid that being an excluded claim that or any dispute arising. That's another reason why why it's preferred to say physical loss of or damage to.
Thank you very much for that, Yeda. So I think now is the time that we will pass on to you for your section. We did have one or two issues, I think, there with your audio. So I will let you know if we do have any more issues, but it seems to be okay for the time being. So let's go ahead.
Right, if we can have the next slide then, please, Tony. Which is one of the main exclusions applicable to the whole of an aviation policy is the AV48B, war hijacking and other perils exclusion. This clause has been in use since the 70s. It was updated very briefly, but just modernized a little bit in 96. Before that, it was actually introduced in 71, and it came from the increased activity from terrorist acts in particular in the late 60s. And before that, before the AV48B, there was a general war clause which excluded loss or damage, which occurred as a direct or indirect consequence of a list of perils. The 48B became a clearer clause and listed the perils, and specifically introduced paragraph B, the hostile detonation of any weapon of war employing atomic or nuclear fission and or fusion or other like reaction of radioactive force or matter. And it also made reference to civil commotion, terrorism acts and malicious acts and acts of sabotage, and also hijacking. Prior to those times, we hadn't really had hijackings as such. So it was it wasn't that the market or the markets wouldn't cover some of these perils. It was more that they needed to be listed out so that they could be identified for those that could be written back and coverage could be provided. Each of the terms used in the exclusion would be subject to definitions, and most of them have been tested in a court of law, because obviously an insured who has a war exclusion on his policy and his aircraft is damaged because there is strikes or riots of a civil commotion would be a bit upset if he then doesn't have access to coverage. But it's not appropriate under the all risk policy, under the hull policy that covers a normal accidental loss, to include those perils, because they are the result of somebody doing something deliberately, usually maliciously. So that's why these exclusions are listed out in the manner that they are. We can write the perils back, as I said, or give coverage for the perils. There are different ways of doing it, and those methods will be covered later on in the sessions. But there is an international agreement between the markets the aviation market and the specialist markets, that paragraph B cannot be written back under any circumstances, because that whether your aircraft is involved or not, if this happens, the hostile detonation of weapon of war, that is a market-changing event, and we should not be providing that coverage. We should, the market needs to take a step back if it happens. But individual aircraft damage arising from any of the other perils can be covered, but subject to the terms and conditions of the methods of the right back that's being used. It was interesting to see that that when the clause was updated or introduced in the late 60s, early 70s, that malicious acts or acts of sabotage was included, although they would be considered the type of perils that might be in A, under the War Invasion Act of foreign enemies. But in fact, malicious acts or acts of sabotage can actually be simply directed at a business, not from a state actor. And it's the same with strikes and riots and civil commotion. They do not need to be agitators on a state plan, more on an individual and affecting businesses, individual businesses. And those type of coverages can be, as I said, can be written back. Can I have the next slide, please, Tony? Right, the next slide is the footer, effectively the footer of the exclusion. It provides that the policy also does not cover any claims, i.e. damage to the aircraft arising while or damage to property that arises whilst the aircraft is outside of the control of the insured by reason of any of those above listed perils. So any other damage that might arise during the time that an aircraft is outside of the control of the insured is also not covered, even though it might not have been anything to do with the peril that's the cause of the insured not having control of the aircraft. And then, of course, there is then a clarification that states as to when the aircraft is considered to be back under the control of the insured, and it confirms that actually it has to be parked with the engine shut down and under no duress, meaning that nobody else is in charge of the aircraft. So and that it is also within the geographical limits of the policy. So that's the exclusion. This exclusion will now be found, and has since the 70s been found on every hull and liability policy, the perils excluding for both hulls and liabilities. And that is all I have to say on this subject. Thank you very much.
Thank you, Yeda. And we have got a couple of questions, but I think we'll allow Sophie to speak first, and then we can deal with those questions. So you can take a quick look in the Q&A now, Yeda, and you'll see the questions that have been posed. Right. But for now, I'll hand over to Sophie.
Okay, then could I have the next slide, please? Okay, so Yeda developed AVN48B, which is the war and allied perils exclusion. And I'm then going to talk to you about the right back for liability, which is AVN52. There are several AVN52 clauses, but the one applicable for aircraft operators and airlines in particular, which is the subject of today, is AVN52E. As Yeda mentioned already, AVN52 basically writes back all the paragraphs of the exclusion of AVN48B except paragraph B. At least that's what's usually indicated on the slip. And that paragraph B, as indicated by Yeda, is the use of atomic nuclear bombs. It has to be borne in mind that when the clause was drafted, certainly people had in mind at that time the type of atomic bombs that was used in Nagasaki, Hiroshima, the type of major nuclear weapons. In the meantime, there have been the development with the situation, the end of the situation in Russia and the end of the Soviet Union. There's been the development of a scare of minor, smaller, perhaps atomic bombs, smaller nuclear bombs. And just for your information, at some stage around, I think it was in 2006, around that date, there was clauses drafted on the market to cater for all these new threats, which were the use of the hostile use of radioactive contamination, the hostile use of electromagnetic pulse, and also the use of chemical or biological materials. And these are clauses AVN48C, AVN48D for the exclusions, and the write-backs, which are AVN52H and AVN52K. These clauses are not really used on the market, but just that you know that they exist, and that the exclusion B in the AVN48B, which is not written back by AVN52E, really relates to a major atomic bomb that can be used in a major war. There's an interesting exclusion that is specifically written in AVN52E and all other AVN52s, which is an exclusion of all the damages on the ground that could occur outside Canada and the USA. Unless caused by or arising out of the use of aircraft. Clearly, the intent behind the exclusion under AVN52E and the other AVN52s is to avoid, catastrophic, the type of situation we are seeing these days in Ukraine, or we've been seeing in Syria or elsewhere, where the damage on the ground are so huge as to be nearly uninsurable. The odd thing really is that there is this caveat for the damages in Canada and USA, but the origin is probably in the history of this exclusion. It clearly would make sense if to have an exclusion in case there is a major war occurring in a country where it becomes impossible to cover the entire situation on the ground when it's not linked to an aircraft accident. But it's an odd wording, and it's interesting to see that sometimes when you have very old exclusions, you keep sometimes wordings which are a bit strange. Next slide, please. Just the important point about AVN52E is the limit. The limits have changed over time. There has been before and then after 9/11. Prior to 9/11, for those of you who are young enough not to have been present on the market at that time, clearly the write-back of AVN52 at that time, which was 52C, was a full write-back in terms of limits. The full policy limit, the CSL, the combined single limit, was written back, applicable to all covers, or at least the applicable policy limit was applicable for the AVN52 write-back. Then there was 9/11 and the immense, huge extent of damages on the ground. As you perhaps know, or if for those of you who wouldn't know, at that time, the market was, of course, completely scared by the extent of the damages on the ground, which had been caused by the terrorist attacks of 9/11. There was a cancellation of all the war liability coverage which were in place, and we will see that quickly, which is the possibility to cancel the policy, to terminate it with 7 days prior advice. So everything was cancelled in terms of coverage, which was of course a big issue for the operators and the brokers, and a limited coverage was put in place, but very limited, which was only 50 million in the aggregate for third-party liability, mostly having in mind the problems of the damage, the possible damage on the ground, which are extremely difficult to assess, as the 9/11 has shown, with very huge damages, which are in billions of dollars. And now the situation gradually has improved, and as of today, we have AVN52E, which is along the same logic, basically that for passenger, baggage, cargo, mail, there is full limit applicable as for the non-war risk. But for damage on the ground, for third-party liability, there is a sublimit, which is a sublimit per occurrence and in the aggregate, which is included in the full policy limit. And the amounts, of course, are now higher and more flexible. It could be $150, $250 million, 500 million, perhaps sometimes more. It's up to the underwriters and the brokers to agree on the limit, but there is a specific sublimit for third-party liability. Next slide, please. So with respect to this war coverage, and in particular the liability one, which is the AVN52, there is, of course, always the need to adjust to the political situation and the risk on the planet. And so you have a very specific provisions relating to termination and early cancellation of the coverage. Basically, you have three possibilities of automatic termination. One is basically a new third world war, which would be a war involving at least two of the five main superpowers, or at least the members of the Permanent Council of the United Nations, which are France, the People's Republic of China, the Russian Federation, the UK, and the USA. So in case of war between two of these countries, it's automatically terminated, no more war liability coverage. There is the situation of the use of an atomic bomb, which would immediately, automatically terminate the war coverage, I mean the coverage under subparagraph A of AVN48D, which is basically foreign war, civil war, etc. But not the others, which can be terminated, but at least with a notice. And the third automatic termination situation is in case of requisition for title or use of an aircraft. And for that aircraft, coverage and the war coverage would immediately stop upon such requisition. Of course, if an aircraft is in the air at the time one of these events occurs, it's covered until it has landed and the passengers have disembarked. Next slide, please. The non-automatic possibility of terminating the coverage are a short notice possibility to terminate the policy, to cancel it, which is a 7 days notice. Cancellation can be at the initiative of the insurers or the insured. The insurers may also, with a 7 days notice, alter the geographical limits. So when there is a situation deteriorating in an area of the world, the insurers might, with 7 days notice, decide to exclude some of the countries where war is starting or foreseen from the coverage, and they can review the premium as well. And there is 48 hours also limited cancellation possibility, which is for all the write-backs of AVN48B except war, because war is automatically terminated, and that's again only in case of the use of an atomic bomb, an atomic weapon. I think it's the end of my part on AVN52, but just to check, next slide, please. That's it.
Thank you very much, Sophie. That was really valuable. And we have now got the opportunity to answer a couple of questions that have come in to the Q&A function. So thanks everyone for providing those. I think we'll start perhaps in the reverse order with one that we won't be able to comment on. So the question is, do you think that the ongoing situation in Russia, Ukraine will have an impact or force an amendment in the clauses used? So as I said, something that we wouldn't be able to comment on at this time, but just from my perspective, it is worth mentioning that the process to develop new or to review current AVN clauses in the market is via the Aviation Insurance Clauses Group. That's the AICG. And actually, Sophie, Gareth and Yeda all sit on that group, and the Secretariat is provided by the IUA. So I do also sit on that group. The group is made up of IUA and LMA wordings experts, along with some independent wordings experts in the market. It is an independent group that will consider any request to develop a new AVN or to reconsider a current AVN. It may also wrap into another question which has been asked, which is, can we still use the AVN 52C and D, or should it always be 52E? And it's fair to say that from a technical perspective, a clause is not withdrawn by the AICG. That clause is still in existence, but there are, of course, further iterations, and I'll allow Yeda to add to that. But the final point may be to say that, of course, it is very early in terms of the ongoing situation. And of course, it will be a firm by firm decision as to how the response to that develops. Yeda, did you want to add perhaps first on 52C and D?
Yes, I can do. Can you hear me?
We can.
Excellent. 52C and 52D were not withdrawn, as you say, but they were recommended not to be used because they had the original $50 million limit stated in there. And we were subsequently, as a market, advised that we couldn't have pre-agreed limits in clauses, because that would possibly amount to anti-competitive behaviour. And this followed the EU investigation into how the market evolved after the 9/11. So because the C and D were both drafted with 50 million in them, we stopped using them, and the clauses were republished with blanks. And as we've seen, in fact, as the market has evolved over time and risk appetite has returned, those initial limits, 50 million, has now increased in some cases up to as high as 350.
Thank you very much, Yeda. Okay, so
I can take the other questions as well.
Please do.
Or at least start on them, and then my colleagues can perhaps add to it. There's a question. Please, could you explain what you mean by a market-changing event and why this is a problem? Why insurers need to step back when referring to 48B? And of course, that is I wasn't referring to it within the exclusion, because the exclusion's fine. Insurers don't have to worry about it because they're just not covering it under the all risk policy, under the hull and liability sections. What I meant was that in terms of writing back the perils, the paragraph B cannot be written back because it would be a market-changing event, and actually probably most likely a world-changing event, and that everybody would have to regroup. A hostile detonation of a sorry, that was confusing. I was reading the next question. The hostile detonation of any weapon of war employing atomic or nuclear fission, as Sophie said, we envisaged when the clause was drafted something like the Hiroshima, etc., and that would be world changing, and the insurance market, the commercial markets, would not necessarily be able to cope with consequences of those type of events. And they're of course not directed at an operator, they're directed at states, and therefore are not necessarily within the commercial realm. And that's why that particular paragraph cannot be written back in either under 52E or under the hull war right back clauses or wordings. So that's the reason for that. There is a second question, which is, what is a recognized definition of war? And there is, but it's one definition: a state of armed conflict between different countries or different groups within a country. But as, of course, paragraph A of AV48B has a number of terms in there that may or may not be war, as we perhaps as a layperson would understand war, simply because there isn't, you know, I suppose I can go back to one person's terrorist is another person's freedom fighter. There's different definition depending on where you come from and how you view a conflict. So the exclusion is there to try and capture the type of activity that constitute or would constitute a definition of war. We did have, just to add a little bit of information on that, we did have some clarification some years ago when there was activity ongoing in, I think, Afghanistan, where certain operators came in via their brokers and asked for confirmation that certain types of activity which could perhaps be considered to be maybe rebellious or whatever, but it was in fact offending against rebels, that wouldn't necessarily constitute a peril as excluded under paragraph A of the AV48B. And depending on the circumstances and the activity that we were looking at, in some cases that language was agreed that certain activity would not be considered a peril under paragraph A of 48B, obviously under the all risk policy, and therefore wouldn't be an exposure that would be expected to be covered under a right back.
Thank you, Yeda. That's
and then we got one more question. Oh, well, maybe that's for Sophie.
I was not about to answer the last question. Just wanted to add something to what I presented, because I mentioned the AVN52E right back for liability, but just to mention that beyond AVN52E, you have the possibility, of course, for operators to buy additional excess war liability covers up to the full limit of the policy usually. So there's a market for that. And before the market, as I mentioned, after 9/11, gradually the market took strength again and provided better and better solutions for coverage to the insured. But in the meantime, there had been a number of mechanisms adopted by states, and in particular by the US, which you know of, which is the TRIA, the Terrorist Risk Insurance Act, which has evolved under the TRIPRA and other complex acronyms. But basically, there are solutions which have been put in place by various states to cater for the situation such as the one that occurred at 9/11, where the market basically disappears. The market for war covers disappears in a matter of days, and to provide solutions which can be lasting for insureds. And in the meantime, of course, the market has recovered and is now able again to provide solutions, including up to the full limit for third-party liability, but not just on the main policy by buying an excess war liability cover. Just wanted to add that. Maybe there's a question I should answer, or Yeda, you want to answer it?
Yeah, but I'm quite happy to answer question 5 from a theoretical perspective, if you want. It says here, if an aircraft was having maintenance carried out by a third-party company, will they therefore not be covered under 48B, but then with 52E right back, they are covered? So there's different things there. Today, we are addressing the the aircraft operators policy. And the aircraft operators policy, we're presumably assuming that an aircraft has crashed, and the aircraft operators policy will respond. And it will respond presumably under the liability section to persons that have been injured on board the aircraft, or under the hull section for the aircraft damage itself. If subsequently investigation into the accident indicates that it was the maintenance company that was faulty, so that's a third party, that would allow underwriters to subrogate against that third party. If it's subsequently then is discovered that the reason that the maintenance was faulty was because somebody had maliciously performed some faulty or had deliberately damaged something with a view to cause it, then the maintenance facility would have the cover excluded under 48B, but they would buy coverage for malicious for the right back under a clause called AV52G, which provides similar coverage to AV52E, but again with a sublimit. So the maintenance organisation should be covered even if the damage is caused by an excluded peril that's been written back. I don't know if that answers the question for the.
Yeah, I think it does, Yeda. Thank you very much for the response, and also Sophie for yours, and for the questions provided. So please do continue pasting your questions into the Q&A facility as we move through the second half of this session now. So I think I'm going to go back to Gareth now to take us on.